91%! That's how many people sign contracts without reading them. A study by Deloitte found that the vast majority of us agree to terms we don't understand. And here's where it gets scary. Contract disputes make up about 60% of the roughly 20 million civil cases filed every year. That's 12 million lawsuits every single year. Think about that for a moment. You are statistically more likely to face a contract dispute than almost any other legal problem in your life. And most people, they have no idea how these agreements actually work. They sign, they hope for the best, and then they get burned. But not you, not after today. Because in this free course, I'm going to teach you everything you need to know about contracts, the elements that make them legal, the traps that catch people, the exact steps to protect yourself, and the secrets that even some lawyers don't explain clearly. By the end of this hour, you will understand contracts better than 90% of the population. You'll know how to read them, how to spot danger, and how to use them to your advantage. So let's begin, right now. Contracts are not just for lawyers and big corporations. They are everywhere in your daily life. Plus, when you tap I agree on your phone, sign a lease for your apartment, shake hands on a freelance job, or even buy a coffee with your credit card, you are entering contracts every single time. Research from the University of Law shows that more than 2/3 of people don't read or don't understand the contracts they sign for basic things like subscriptions and utilities. That's terrifying when you think about it, because what you don't understand can hurt you. The median cost of a contract dispute lawsuit, according to court statistics, it's around $91,000. That's not a small number. That's potentially your savings, your business, your peace of mind, gone, because of words on a page you didn't understand. So here's my promise to you today. By slide 60 of this course, you will understand. You will know what makes a contract legal. You will see the warning signs, and you will have the power to protect yourself and your money. Let's keep moving. So what is a contract? Let me make this simple. A contract is a legally enforceable promise between two or more parties. That's it. But those words, legally enforceable, those are the key words. They mean a court can force someone to keep their promise, or pay you money if they don't. Think about it like this. If your friend says, "I'll help you move next Saturday," that's a promise, but it's not a contract. Why? Because there's no legal enforcement, no obligation, just trust. But when you sign a document at a moving company, now we're talking about a contract. The Legal Information Institute at Cornell Law explains that most contract law comes from state common law. This means judges have been deciding contract cases for hundreds of years, and their decisions have built up a system with rules that you're about to learn. Here's the beautiful thing. Once you understand these rules, contracts stop being scary. They become tools. Tools you can use to make deals, build businesses, protect relationships, and create security. So let's look at what makes a contract actually valid. Every valid contract needs 6 essential elements. Miss even one, and your contract might be worthless. According to contract law experts, these elements are offer, acceptance, awareness, consideration, capacity, and legality. 6 elements. Let me repeat them. Offer, acceptance, awareness, consideration, capacity, legality. I want you to memorize these 6 words. Seriously. Say them out loud with me. Offer, acceptance, awareness, consideration, capacity, legality. Good. Now, you might be thinking, okay, but what do these actually mean? Don't worry. We're going to break down each one in detail. Ironclad's legal research confirms that missing even one element can render an entire agreement unenforceable in court. That's right. You could have a beautiful 20-page document with signatures and dates and witnesses, and if it's missing one element, worthless. But here's the good news. These elements aren't complicated. They follow logic. They make sense when you understand them. And once you know them, you'll see them everywhere. You'll become a contract detective. Let's start with element number 1. Element 1 is the offer. The offer is where everything begins. Without an offer, there's nothing to accept. And without acceptance, there's no contract. Simple, right? But let's go deeper. An offer is a proposal from one party to another. Plus, it's like when a car dealership puts a price tag on a vehicle, when your potential employer sends you a job description with a salary, or when a freelance client emails asking if you'll design their logo for $500. These are all offers, clear proposals with specific terms. The person who makes the offer is called the offerer. The person who receives the offer is the offeree. And here's something important. An offer must be specific. It must contain definite terms. Plus, if someone says, "Maybe I'll sell you my car someday for some amount of money," that's not an offer. But if they say, "I'll sell you my Honda Civic for $8,000, now you have an offer. Legal experts explain that an offer communicates the offerer's terms clearly. It basically says, "These are the conditions I'm willing to accept in a legally binding agreement." Once that offer exists, the offeree has choices. They can accept, reject, negotiate, or simply ignore it. Let's see what happens next. Not all offers last forever. An offer can expire or become invalid in several ways, and understanding this can save you from big mistakes. First, the offerer can revoke the offer before acceptance. They can simply say, "Never mind," and pull it back. Second, the offer can have a time limit. Plus, if a job offer says, "You must respond by Friday," and you respond on Monday of the next week, that offer is dead, gone, no longer valid. This happens all the time with real estate deals, employment offers, and business negotiations. Third, the offeree can make a counteroffer. Contract law research shows that a counteroffer terminates the original offer. Plus, so if someone offers to sell you a bicycle for $200 and you say, "How about $150?" the $200 offer no longer exists. You've created a new offer at $150. Fourth, and this is important, the death or mental incapacity of the offerer can end an offer. It sounds dark, but contracts are about living agreements. If the person making the offer passes away before acceptance, there's no meeting of minds, no contract. Let's move to element 2. Element 2 is acceptance. This is where the offeree says yes to the offer's terms. But here's the crucial part. Acceptance must be unambiguous. It must be clear. It must match the offer exactly. Legal scholars explain that for acceptance to be valid, it needs to mirror the terms of the offer. If you change any part of the offer, that's not acceptance. That's a counteroffer. It restarts the whole process. The original offer dies. There are two types of acceptance. Express acceptance is when you clearly state or write, "I accept." This happens when you sign your name on an employment contract, when you reply, "Yes, I'll do the job," to a client, or when you click the "I agree" button on a website. Simple acceptance is when your actions show acceptance. Plus, starting work before the contract is signed, moving into an apartment before paperwork is complete, or beginning to deliver goods, these can all count as implied acceptance. And here's a critical point. Silence is not acceptance. If someone sends you a contract and you don't respond, you have not agreed. You cannot be bound by ignoring something. This protects you from being trapped into agreements you never wanted. Element 3 is awareness. Some people call this mutual consent or meeting of the minds. It means both parties must know they're entering an agreement. They must understand what they're agreeing to, and they must do it freely. According to legal experts, for a contract to be valid, all parties must acknowledge that the contract exists. They must agree they are bound by its terms. And this must happen through their own free will. No tricks, no lies, no force. This element protects people from fraud, deception, and undue influence. Plus, if someone signs a document thinking it's a birthday card, but it's actually a loan agreement, there's no awareness. If someone tricks you into signing something in a language you don't understand, no awareness. If someone forces you to sign at gunpoint, absolutely no awareness. The goal here is fairness. Both sides must know what they're doing. Both sides must understand the consequences. If there's no meeting of the minds, the contract can be voided, canceled, thrown out by a court. This is your protection against bad actors. Element 4 is consideration, and this is what separates a contract from a simple promise. Consideration means something of value must be exchanged between the parties. Both sides must give something, both sides must get something. The Legal Information Institute explains that a promise is only enforceable when supported by adequate consideration. This means something must be exchanged to induce the promise. In a job contract, you give your time and skills, and your employer gives money. In a sales contract, the buyer gives money and the seller gives the product. Consideration doesn't have to be money. It can be goods, services, a promise to do something, or even a promise to not do something. If I promise to pay you $10,000 if you promise not to open a competing business near mine, that promise not to compete is valid consideration. Legal experts have noted that courts usually don't judge whether the consideration is fair. You can enter into a bad bargain. You can agree to sell your car for $1. As long as something of value is exchanged, consideration exists. The contract can be valid. Here's something that confuses many people. A gift is not a contract. Why? Because there's no consideration on both sides. If I simply give you money with nothing in return, that's generosity. That's kindness. But it's not legally enforceable. Think about birthday presents, charitable donations, or when your parent gives you money just because. These are one-way transfers of value. There's no exchange, no bargain, no mutual obligation, and therefore no contract. This is why promises to give gifts can be legally tricky. If your rich uncle says, "I'll give you $50,000 when you graduate," and then he changes his mind, you might not be able to sue him, because you didn't give anything in exchange for his promise. There was no consideration. But there are exceptions. Something called promissory estoppel can sometimes make gift promises enforceable if you relied on them significantly. If you quit your job, moved across the country, and changed your whole life based on that $50,000 promise, a court might enforce it. But that's advanced stuff. For now, remember, no exchange, no contract. Element 5 is capacity. This means all parties must have the legal ability to enter into a contract. They must be able to understand what they're agreeing to, and they must be legally permitted to make binding agreements. Legal research shows that capacity comes down to several factors. First, age. In most places, you must be at least 18 years old to sign a contract. Minors can sometimes enter agreements, but they often have the right to void those contracts later. Second, mental competence. A person must be able to understand the nature and consequences of their actions. If someone is severely intoxicated, suffering from dementia, has a mental disability that prevents comprehension, or is under extreme psychological distress, they may lack capacity. Their signature might mean nothing. Third, in business contexts, the person signing must have authority to bind their organization. If a random employee at a major corporation signs a $1 million deal without permission, that company might not be bound. Always check, does this person actually have the power to make this agreement? Element 6 is legality. The contract's purpose must be legal. The actions required must be lawful. If a contract involves illegal activities, it's automatically void. No exceptions. Contract law experts are clear on this point. Even if all other elements are present, a contract won't be enforceable if its purpose is unlawful. Contracts need to comply with local, state, and federal laws to be considered valid and enforceable. Think about it this way. You cannot legally contract with someone to commit a crime, to defraud a third party, to violate gambling laws, or to do anything that violates public policy. A judge will never enforce such agreements. In fact, both parties could face criminal charges for even attempting them. This also applies to contracts that seem legal but have illegal terms hidden inside. If an employment contract says you must work more than legally permitted hours, if a rental agreement violates housing laws, or if a sales contract includes fraudulent guarantees, those specific terms are unenforceable. And sometimes, the whole contract falls apart. Now here's a question I get all the time. Do contracts have to be written? The answer might surprise you. Most contracts can be oral. A handshake deal can be legally binding, but should you rely on oral agreements? Absolutely not. The University of Law research suggests that even when people have written contracts, most don't read them. Imagine how much harder it is to enforce something that was never written down at all. You have no proof, no documentation, just your word against theirs. There's also something called the Statute of Frauds. This legal rule requires certain contracts to be in writing. Plus, these typically include contracts for the sale of land, agreements that take longer than 1 year to complete, promises to pay someone else's debt, and contracts above certain dollar amounts. Without writing, these are void. My advice? Always get it in writing, even if the law doesn't require it. A written contract protects both parties. It creates clarity. It prevents misunderstandings. And if things go wrong, it becomes your evidence, your shield, your sword. Contracts come in many forms. Understanding the types helps you navigate different situations. Let's look at the main categories you'll encounter in real life. Bilateral contracts are the most common. Both parties make promises to each other. Plus, I promise to pay you, and you promise to deliver the product. I promise to work, and you promise to compensate me. I promise to rent the apartment, and you promise to provide a livable space. Two-way promises, mutual obligations. Unilateral contracts involve a promise from one side that's fulfilled by action from the other. Plus, a reward poster is a classic example. I promise to pay $1,000 to whoever finds my lost dog. You don't promise to find the dog, but if you do find it, I must pay. The action is the acceptance. Express contracts have terms that are clearly stated, either verbally or in writing. Implied contracts have terms that are understood based on circumstances and conduct. Plus, when you sit down at a restaurant, order food, and eat it, you've entered an implied contract to pay for that meal. Nobody signed anything, but the obligation exists. Not all contracts are created equal. Some are fully valid, some are completely void, and some are voidable. Understanding these categories could save you from disaster. A valid contract has all 6 elements we discussed. It's legally enforceable. If someone breaks it, you can take them to court. You can seek damages. You can demand performance. The law is on your side. A void contract is nothing. It never existed in the legal sense. According to legal scholars, contracts are void when the subject matter is illegal or when one party doesn't have competency to contract. Plus, a contract to sell illegal substances, an agreement signed by a 5-year-old, a deal to commit fraud, these are all void. No enforcement, ever. A voidable contract is interesting. It starts as valid, but one party has the right to cancel it. Legal experts explain that contracts created under undue influence, coercion, fraud, or with a minor are voidable. The affected party can choose to enforce it or void it. The choice is theirs. Let's talk about what happens when things go wrong. A breach of contract occurs when one party fails to perform their promised obligations. They don't deliver what they promised. They don't pay what they owed. They violate the terms. The Cornell Law School explains that breaches are so common, a robust body of law has developed to resolve these disputes. The overarching goal is to put the harmed party in the same economic position they would have been in had no breach occurred. There are different levels of breach. A minor breach is a small violation that doesn't destroy the whole purpose of the contract. Plus, if a delivery arrives one day late but everything else is fine, that's minor. A material breach is major. It undermines the core purpose of the agreement. Plus, if you ordered a red car and they delivered a boat, that's material. An anticipatory breach happens when one party indicates they won't fulfill their obligations before the deadline. Plus, if your contractor says, "I'm not going to finish your house," halfway through the project, you don't have to wait for the deadline. You can act now. You can seek remedies immediately. Breaking a contract is not free. There are real consequences. Financial consequences, professional consequences, sometimes even personal consequences. Let me show you what's at stake. Research shows the median cost for a contract dispute lawsuit reaches around $91,000. That's just the legal costs. That doesn't include the actual damage might have to pay, the lost business, the ruined reputation. Statistics reveal that roughly 90% of all businesses experience a lawsuit at some point, and contract disputes are the #1 type of business lawsuit. Not accidents, not discrimination, contracts. That's how common this is. Beyond money, breaking contracts damages trust. It hurts relationships. It closes doors. Word spreads in industries. Plus, if you're known as someone who doesn't honor agreements, future partners avoid you, clients hesitate to hire you, and vendors demand cash up front. Your reputation becomes your prison. When someone breaks a contract, the law provides remedies. The most common remedy is damages, money, compensation. Let's understand the different types of damages available. Compensatory damages are the most basic. Legal experts explain these are based on the actual losses you suffered because of the breach. Plus, if someone agreed to sell you a car for $10,000 but backed out and you had to buy a similar car elsewhere for $12,000, your compensatory damages are $2,000. Simple math. Conventional damages go further. These becomes the differently remember. These are real compensatory damages for compensatory selfer. Compensatory damages, there's the important for front point. The damages of 15% of the text. There's no many pressures of the law that included in the first. Legal experts are the different for front point. Let's start it here. The breach is those of the teacher damages of properly $1,000 improved to the breach. Let's bejoin him again. The damages made to be the under them won those place, and then the breach is the contract. If you live the damages that the breach discovered there, we'll be watching for a business and another world, but the breaches are the damages. This is like the most future contract with legal institute, would also verge the expansion of the trackling. Plus, if someone agreed to sell you a car for $10,000 but backed out in many times continue the provides free them. Nobody is first to descripted the breach. The breach is the cruelly one and displayed, but the reason will go out and then they're only rented the 2-minute self. This is the chamber of there or someonewhere of a law. Then they will move up a Japan craft in the game of penned. Those from again for much of me in the game of the room. The breaches is at least still not be able to trackling for me. But they real compensatory damages, they made hit them to first basically with breach. But they believe them is more than increased in damages, but they really get reminded on the breach. Let's talk about what compenses for though that you can do. If someone agreed to sell you a car for $10,000, but they remember that you need to first me. And some, if you're anything that would be heavy to close. Video the day of perform coming up with damages, it's really not to kick down in the meeting, but it's the most lessful needed. Let's start to subscribely anything. The breach is not the ingredient because. Further, These cover losses that result from the breach but aren't directly caused by it. Plus, if that car you couldn't buy was going to be used for your pizza delivery business and you lost $10,000 in pizza sales while waiting, those lost profits could be consequential damages. Liquidated damages are pre-agreed in the contract itself. Plus, many construction contracts say, for every day past deadline, the contractor pays $500. These predetermined amounts save everyone the hassle of calculating damages later, but they must be reasonable, not penalties. Sometimes money isn't enough. Sometimes you need something more. That's where non-monetary remedies come in. These are called equitable remedies, and courts use them in special circumstances. Specific performance is powerful. According to legal research, courts can order the breaching party to actually perform their contractual duties. Plus, if someone agreed to sell you a unique piece of land and then refused, a court might force them to complete the sale. You get the land, not just money. Legal experts note that specific performance is a disfavored remedy used only when money can't solve the problem. Courts ask, is the subject matter unique? Is it irreplaceable? Plus, real estate, one-of-a-kind art, rare collectibles, custom-made items, these often qualify. Rescission means canceling the contract entirely. Both parties are released from their obligations. It's like the agreement never happened. Reformation means changing the contract to reflect what the parties actually intended. Plus, if a typo changed 1,000 to 100, a court can fix it. Here's something many people don't know. If someone breaches a contract with you, you have a duty to mitigate. That means you must try to reduce your losses. You can't just sit back and let the damages pile up. Plus, think about it this way. If your tenant breaks their lease and moves out, you can't leave the apartment empty for a year and then sue for 12 months of rent. You have a legal obligation to try to find a new tenant, to minimize your losses. This doesn't mean you lose your right to damages. It means you can only recover damages that you couldn't reasonably avoid. Plus, if you tried to find a new tenant but couldn't for 3 months, you can recover those 3 months, but not the months you could have avoided with effort. The mitigation doctrine exists for fairness. Courts don't want people profiting from breaches. They want to make injured parties whole, not wealthy. So always ask yourself, what can I do right now to reduce the damage? That effort will help your case later. Now let's get practical. How do you actually read a contract? Because remember, according to research, 69% of consumers admit to signing contracts without knowing all the details. Don't be part of that statistic. First, read the entire document. I know it's long. I know it's boring. But every single word matters. Courts have said that if you sign a contract, you're generally bound by it whether you read it completely or not. Ignorance is not a defense. Second, look for key sections. These include the parties involved, the obligations of each party, the payment terms, the duration, the termination clauses, the dispute resolution methods, and the penalties for breach. Third, identify words you don't understand and look them up. Research from Boston College Law shows the average contract requires more than 14 years of education to understand. Don't be embarrassed to use a dictionary, or ask for plain language explanations. Some contract clauses are more dangerous than others. These are the ones you must watch for, the ones that can trap you, the ones that cost people thousands of dollars every year. Automatic renewal clauses can lock you in forever. Plus, your gym membership, your software subscription, your phone contract, many automatically renew unless you cancel before a specific date. Studies show 82% of people don't check updated terms in contracts that automatically renew. Arbitration clauses can take away your right to sue in court. Instead, disputes go to a private arbitrator. This isn't always bad, but it can favor the company that wrote the contract, and you might lose important legal protections. Limitation of liability clauses can cap how much you can recover if things go wrong. Plus, A moving company's contract might say their maximum liability is $100, even if they destroy your entire $10,000 furniture collection. Read these carefully. Before you sign any contract, ask yourself these critical questions. Write them down. Make them your checklist. They could save you from terrible mistakes. Question 1. Do I understand every term? If there's anything confusing, stop and ask for clarification. You have the right to understand what you're agreeing to. Never sign something you don't fully comprehend. Question 2. What are my obligations? What exactly must I do? When must I do it? What happens if I can't do it? Many people focus on what they're getting and forget to carefully examine what they're giving. Both sides matter. Question 3. How do I get out of this contract? Every contract should have an exit strategy. Can you cancel? With how much notice? Are there penalties? Plus, some contracts are for life unless you actively cancel. Others have specific end dates. Know your escape route before you enter. Here's a secret many people don't know. Almost everything is negotiable. Contracts aren't set in stone until both parties sign. Before that moment, you have power. Use it. Research shows 64% of small business leaders have avoided signing contracts because they weren't confident they understood the terms. Instead of avoiding, negotiate. Ask for changes. Request simpler language. Start by identifying terms that concern you. Then, propose alternatives. Plus, if a penalty clause seems too harsh, ask for a lower penalty. If a deadline seems impossible, request more time. If a payment term doesn't work for your cash flow, suggest a different schedule. The worst they can say is no. Remember, the other party wants to do business with you. They drafted this contract because they want a deal. That gives you leverage. Use polite, professional language. Explain your concerns. Propose solutions. You might be surprised how often they say yes. Sometimes contracts are too complex to handle alone, and that's okay. Knowing when to get help is a strength, not a weakness. Professionals exist for a reason. For major contracts, consider hiring an attorney. Plus, this includes contracts involving large amounts of money, real estate purchases, business partnerships, employment agreements, and anything that could significantly impact your finances. The cost of a lawyer is nothing compared to a bad contract. For simpler contracts, online resources can help. Legal websites offer explanations of common terms. Contract review services exist at various price points. Some attorneys offer limited scope services where they review just the contract without full representation. And here's a tip. Many lawyers offer free initial consultations. Use them. Get a professional opinion on whether a contract is fair. Ask what risks exist. Understand your rights. That 30-minute conversation could save you years of problems. Let's look at specific types of contracts you'll encounter. Employment contracts are among the most important. They define your relationship with your employer, your rights, your obligations, your future. Key elements to watch include job title and description, compensation and benefits, work schedule and location, duration of employment, grounds for termination, notice requirements, and restrictive covenants. Restrictive covenants deserve special attention. These include non-compete clauses that limit where you can work after leaving, non-disclosure agreements that restrict what you can share, and non-solicitation clauses that prevent you from taking clients or colleagues. Legal research shows non-compete cases average 600 filings annually, with nearly half also including trade secret claims. Before signing anything that limits your future employment, Think carefully. Negotiate if possible. Understand the consequences. Rental agreements are contracts that touch almost everyone. Whether you're a tenant or a landlord, understanding lease contracts is essential. Mistakes here cost people their homes. Contract dispute attorneys note that leases are among the most common sources of contract disputes. Issues include: who's responsible for maintenance? How are common areas handled? What are the renewal terms? When and how can rent increase? As a tenant, look for the monthly rent amount and due date, the security deposit amount and conditions for return, what's included, utilities, parking, storage, rules about modifications and repairs, the process for ending the lease early. As a landlord, ensure your lease includes clear payment terms, consequences for late payment, rules about property use, maintenance responsibilities, inspection rights, eviction procedures. Many landlords include unfavorable terms in their leases. It's up to both parties to carefully evaluate before signing. Service contracts are everywhere. Hiring a plumber, engaging a web designer, contracting with a cleaning company, or booking a wedding photographer all involve service contracts. Here's what to watch for. Scope of work is critical. What exactly will be provided? Be as specific as possible. Vague language like design services can mean different things to different people. But design of a 5-page website including home, about, services, portfolio, and contact pages is clear. Timelines and deadlines matter. When will work begin? When will it be completed? What happens if deadlines are missed? Are there milestone dates in between? Clear timelines prevent the nightmare of projects that drag on forever. Payment terms should be crystal clear. How much? When is payment due? Is it upfront, upon completion, or in installments? Are there additional costs that might arise? What happens with disputes? Many service providers hide extra fees in their contracts. Read every line about money. Buying and selling goods involve sales contracts. The Uniform Commercial Code governs most of these transactions in the United States. Understanding the basics protects you whether you're the buyer or seller. For buyers, key elements include exact description of the goods, quantity, price, delivery terms, who pays shipping, when and where delivery happens, warranties, what guarantees does the seller make, return policies and remedies if goods are defective. For sellers, focus on payment terms and timing, title transfer, when does ownership officially change hands, risk of loss, who bears the risk if goods are damaged in transit, limitation of liability, return and refund policies. Legal research explains that under the Uniform Commercial Code, a buyer can recover financial losses resulting directly from a seller's failure to deliver goods. The measure of damages is typically the difference between the market price and the contract price. Know your rights. Going into business with someone? A partnership agreement isn't optional. It's essential. Without one, you're asking for disaster. I've seen friendships destroyed, families torn apart, businesses ruined. Statistics show that partnership disputes are among the most common business lawsuits. Partners disagree about purchase or sale agreements, bylaw violations, compensation issues, decision-making authority, and exit strategies. Your partnership agreement should address capital contributions, who puts in what, profit and loss sharing, management responsibilities, decision-making processes, what happens when partners disagree, how partners can exit, what happens if a partner dies or becomes incapacitated. Here's the uncomfortable truth. You need to plan for the worst while hoping for the best. Discuss what happens if the partnership fails. How will assets be divided? How will debts be handled? These conversations are awkward but necessary. Freelancers, listen up. This section is for you. Whether you're a writer, designer, developer, consultant, or any other independent professional, contracts are your protection, your power, your paycheck. Always have a written contract. Never work on just a handshake or an email. Your contract should include detailed scope of work, deliverables, deadlines, payment amount and schedule, revision policies, ownership of work product, who owns what you create. Kill fees protect you if a project is canceled.
If a client hires you for a $10,000 project but cancels halfway through,
A kill fee clause might guarantee you receive 30 to 50% of the total. Without this clause, you might get nothing. Late payment penalties encourage clients to pay on time. Consider clauses like, payments received more than 30 days after invoice date will incur a 2% monthly late fee. Also include what happens if payment is severely delayed, including the right to pause work. The University of Law explains that force majeure clauses define extenuating circumstances that release parties from liability. These acts of God or unforeseeable events became very important during recent global events. Force majeure typically covers natural disasters like earthquakes, floods, hurricanes, war and terrorism, government actions like new regulations or embargoes, pandemics and epidemics, other events beyond anyone's reasonable control. When force majeure applies, the affected party may be released from their obligations without being considered in breach. But this doesn't happen automatically. The clause must exist in your contract. The event must match what's described, and proper notice usually must be given. Review force majeure clauses carefully. What events are covered? What's the process for invoking it? Does performance just pause, or is the contract terminated? These details matter enormously when disaster strikes. You'll often see something called an entire agreement clause. Legal experts note this is a commonly used clause that makes clear the written document contains the complete agreement between both parties. What does this mean practically? Any verbal promises made during negotiations, they don't count. Any emails exchanged before signing, they might not count. Any assumptions you had, they don't count. Only what's in the written document matters. This is why getting everything in writing is so crucial. If a salesperson verbally promised you free upgrades, but it's not in the contract, you probably won't get those upgrades. If your landlord said pets were okay during the tour, but the lease says no pets, the lease controls. Before signing a contract with an entire agreement clause, make sure every promise you're relying on is actually in the document. If something important is missing, add it, or get a separate written confirmation. Verbal assurances mean nothing after you sign. Vague contracts create disputes. Specific contracts create clarity. This principle could save you thousands of dollars and countless headaches. Let me explain why specificity matters so much. The Arcadis Global Construction Disputes Report found that poorly drafted or incomplete contracts were ranked as the top cause of construction disputes. Errors and omissions ranked second. The pattern is clear. Bad drafting causes bad outcomes. Think about the difference. Contractor will paint the house versus contractor will apply 2 coats of Benjamin Moore exterior latex paint in color White Dove OC17 to all exterior surfaces, including siding, trim, and doors, excluding the roof, completing work by June 15, 2024. Which contract would you rather have if problems arise? Specific elements to include: exact quantities, precise specifications, clear deadlines with dates, defined quality standards, measurable deliverables. The more specific your contract, the less room for "I thought you meant" disputes. Contract terms come in 2 varieties. Express and experts explain that express terms are provided verbally or in writing, while implied terms are understood based on custom, practice, or law. Express terms are what you can point to in the document. Payment is due within 30 days. Seller will deliver 100 units. Service begins on January 1st. These are clear, written, undeniable. Trickier. Some terms are implied by custom in an industry. If you hire a plumber, there's an implied term that they'll do the work with reasonable skill, even if the contract doesn't say so. Some terms are implied by law, like certain consumer protections. Generally, express terms override express terms. This is why you should always write down anything important. The contract "click them clearly comes" letter in the first part of it, as reasonly special community litter develop together. The contract is domain better, but collected those can be a fuse grow and look like a junk for me.
The new street will must breathe definitely like the supportable control by different limited in the first client points. That's what I want. Furly joined to state anything. The problem have is employed all the precinct questions of them because this is though with lower. But the doctor has still find it listened initiatives. Develop together something in a 26% abridged management contract that usually like out there what's implied. Make it explicit, make it clear, make it enforceable.
You'll see the term pro rata in many contracts. It comes from Latin meaning for the rate or in proportion. Understanding this helps you calculate what you actually owe or are owed. Contract experts explain that pro rata means you pay an amount for a fraction of a period, according to its share of the whole cost. Here's a simple example. Your monthly subscription costs $30, and it's billed on the 1st of each month. You sign up on the 15th. Pro rata billing means you pay $15 for that first half month, then $30 for each full month after. Pro rata applies to many situations: partial month rent, yearly fees when you cancel early, salary calculations for employees who start or leave mid-pay period, and dividend distributions to shareholders. When you see pro rata, think proportion, fair share, calculated portion. Indemnification clauses can be some of the most important and most confusing parts of a contract. Let me make them simple. Indemnification means one party agrees to protect another party from certain losses or claims. Think of it like insurance within a contract. If someone sues you because of something I did, I'll cover your costs. That's the basic idea. The indemnifying party agrees to compensate the indemnified party for certain losses. Watch for one-sided indemnification. In many business contracts, the stronger party demands that you indemnify them, but not vice versa. This means you're taking on all the risk. That might be okay in some cases, but understand what you're agreeing to. Key questions to ask. What losses are covered? Are there caps or limits? What's the process for making an indemnification claim? Does the indemnifying party have to defend lawsuits or just pay damages? Are there carve-outs for the indemnifying party's own negligence? Confidentiality agreements, also called non-disclosure agreements or NDAs, are everywhere in business. They protect sensitive information. They create legal obligations around secrets. Understanding them is essential. An NDA typically defines what information is considered confidential, who can access that information, how long confidentiality lasts, what happens if confidentiality is breached, exceptions like information that becomes public through other means. Be careful with broad NDAs. Some companies try to make everything confidential, including your work experience, skills you develop, and general industry knowledge. This can severely limit your future career options. Push back against overly broad definitions. Also, watch the duration. Some NDAs last forever. Others expire after a certain period. Consider what's reasonable. Trade secrets might deserve permanent protection, but general business information? Maybe not. Where legal disputes get resolved matters more than you might think. Jurisdiction and venue clauses determine which states or countries' laws apply, and where you'd have to go to court. Imagine you live in California, but you sign a contract with a company based in New York. The contract says, all disputes shall be resolved in New York courts under New York law. If problems arise, you might have to fly across the country to fight your case. Negotiate for your home jurisdiction, or at least a neutral venue. Having to litigate in a distant location can make pursuing legitimate claims impossible due to cost and inconvenience. Also consider, are you waiving your right to a jury trial? Is arbitration required? If arbitration, where does it take place? Who pays the arbitration fees? These details can dramatically affect your ability to seek justice. When contracts go wrong, there are several ways to resolve disputes. Understanding your options helps you both plan ahead and respond when problems occur. Negotiation is usually the first step,
parties try to work things out directly. A phone call, a meeting, an exchange of emails. Many disputes can be resolved simply by communicating. This is fastest, cheapest, and preserves relationships. Mediation involves a neutral third party who helps facilitate agreement. The mediator doesn't decide anything. They help the parties find common ground. Mediation is voluntary, and either party can walk away, but it often succeeds where direct negotiation fails. Arbitration is more formal. An arbitrator, or panel, hears both sides and makes a binding decision. It's like a private court. Research shows many commercial contracts now require arbitration, which keeps disputes out of public courts. Check if your contract requires it.
Even signed contracts can sometimes be voided. Certain circumstances allow one or both parties to escape their obligations. Knowing these can help you attack unfair contracts or defend your legitimate agreements. Fraud voids contracts. If one party made false statements to induce agreement, the contract is voidable. If a seller lies about a car's mileage, a landlord hides major defects, or a business partner misrepresents financial statements, you may be able to void the contract. Duress and undue influence also void contracts. If someone forced you to sign under threat, that's duress. If someone used their power over you, like a caregiver, family member, or authority figure, to manipulate your decision, that's undue influence. Mistake can sometimes void contracts. If both parties were mistaken about a fundamental fact, the contract might be voidable. If you both thought you were contracting for a genuine Picasso, but it's actually a forgery, that mutual mistake could void the deal. You can't wait forever to sue for breach of contract. Every jurisdiction has a statute of limitations, a deadline after which you lose your right to bring a lawsuit. The time limit varies by location and type of contract. Written contracts typically have longer statutes of limitations than oral contracts. In many U.S. states, you might have 4 to 6 years for written contracts, but only 2 to 4 years for oral agreements. The clock typically starts when the breach occurs, not when you discover it. Though some jurisdictions have discovery rules that delay the start in certain circumstances. Check the rules where you are. Why does this matter? If you know about a breach, don't delay. Gather your evidence, consult with a professional, make your decision about whether to pursue legal action. Waiting too long could mean losing your rights entirely. Documentation is your best friend when contract disputes arise. Every conversation, every email, every change, every payment, document everything. Keep copies of all signed contracts in a safe place and in the cloud. Save all related emails and messages. Document phone conversations with follow-up emails summarizing what was discussed. Keep records of all payments made and received. If problems start to develop, increase your documentation. Note dates and times. Describe what happened in detail. Save screenshots. Keep originals of any defective products. Document your attempts to resolve the issue. This documentation becomes evidence if disputes escalate. The party with better documentation usually has the advantage. Courts rely on proof, not memories. The person who can show what happened wins. Contracts aren't frozen in time. Circumstances change. Relationships evolve. Sometimes you need to void an existing contract. Here's how to do it properly. Most contracts can be modified if both parties agree, but the modification should be in writing. Verbal modifications to written contracts create confusion and may not be enforceable. A proper modification should reference the original contract, clearly state what's being changed, specify that all other terms remain the same, be signed by all parties, include the date. Watch for clauses that restrict modifications. Many contracts say, this agreement may only be modified in writing signed by both parties. If your contract has this language, verbal changes definitely don't count. Respect the process. Ending a contract requires care. Improper termination can turn you into the breaching party, even if you had legitimate reasons to want out. Follow the rules. First, check your contract's termination provisions. Most contracts specify when termination is allowed, how much notice is required, what form notice must take, written, email, certified mail, any penalties or consequences. Follow the procedures exactly. If the contract says 30 days written notice sent by certified mail, don't send an email and expect it to count. Technical compliance matters. Courts enforce these requirements. Document your termination. Keep copies of termination notices. Get delivery confirmation. Note the date you sent it and the date it was received. Follow up in writing if you don't receive acknowledgement. Create a paper trail.
Let me give you a checklist of red flags. If you see any of these in a contract, proceed with extreme caution. Ask questions, negotiate changes, or walk away.
Red flag 1. One-sided terms that heavily favor the other party. Everything benefits them. Nothing protects you. Unlimited liability for you, capped liability for them. Their right to terminate at will, but you're locked in. Red flag 2. Vague or undefined important terms. What exactly does reasonable mean? Timely? Satisfactory? If key obligations aren't clearly defined, disputes are almost guaranteed. Red flag 3. Missing exit strategies or impossible termination conditions. You can never leave, or leaving costs more than the entire contract. Red flag 4. Unusual confidentiality or non-compete clauses that seem designed to trap you rather than protect legitimate interests. Research shows several common mistakes that individuals and businesses make with contracts. Learn from others' errors. Don't repeat them yourself. Mistake 1. Not reading the entire contract. We've discussed this. 91% of people don't read. They sign blindly. They regret it later. Don't be them. Mistake 2. Relying on verbal assurances. Oh, we'll work that out later. Don't worry about that clause. We never enforce it. If it's not written, it doesn't exist. Mistake 3. Rushing to sign without negotiation. Mistake 4. Failing to keep copies of signed documents. Mistake 5. Not understanding the consequences of breach. Mistake 6. Signing with incomplete information about the other party's reliability or financial stability. Different industries have different contract norms and risks. Research indicates that construction leads with 20.7% of contracts experiencing disputes. Telecommunications follows at 13.6%. Automotive at 13%. In construction, watch for scope creep, change order procedures, timeline extensions, payment schedules tied to milestones, lien rights, insurance requirements. In technology, focus on intellectual property ownership, licensing terms, service level agreements, data privacy obligations, warranty disclaimers. In creative industries, ensure clarity on copyright ownership, usage rights, revision limits, kill fees, portfolio rights, attribution requirements. Every industry has its quirks. Learn yours. Contracts across borders add layers of complexity. Different legal systems, different enforcement mechanisms, different cultural expectations. Proceed carefully. Choice of law matters enormously. Which country's laws govern the contract? The United Nations Convention on Contracts, CISG, governs cross-border sales contracts for member states. But parties can often choose different governing law. Currency and payment also need attention. Which currency? What exchange rate applies? How are international payments processed? What happens if currency values fluctuate dramatically? Enforcement is the biggest challenge. Even if you win a judgment in one country, getting it enforced in another country can be difficult or impossible. Consider whether the other party has assets in a place where you could enforce judgments. We live in a digital world. Most contracts today are signed electronically. Understanding digital contract law keeps you protected in modern transactions.
E-signatures are generally legally valid. Laws like the U.S. Electronic Signatures in Global and National Commerce Act, ESIN, give electronic signatures the same legal weight as handwritten ones. But not everything can be signed electronically. Some documents still require physical signatures. Click-wrap agreements are contracts you accept by clicking "I agree." Research from Boston College Law found that 99% of such agreements are essentially unreadable, requiring more than 14 years of education to understand. Best practices for digital contracts. Ensure proper authentication of signers. Keep secure records of signed documents. Maintain audit trails showing who signed what and when. Use reputable e-signature platforms with proper security. Consumer contracts have extra protections. Laws exist to protect individuals from unfair business practices. These can override unfavorable contractors. Unconscionability is good in terms to class. Unconscionability is no in both. Consumer contracts a legal doctrine that allows courts to refuse enforcement of contract terms that are extremely unfair. According to legal experts, courts can strike down provisions that no reasonable person would agree to. Warranty laws provide minimum protections for consumers buying goods. Even if a contract says no warranties, certain warranties may be implied by law and cannot be disclaimed.
Consumer protection statutes vary by jurisdiction, but often include cooling-off periods for certain sales, right to cancel, required disclosures, restrictions on certain contract terms, enhanced remedies for consumer claims. Know the laws that protect you. Small business owners encounter contracts more often than almost anyone. According to Adobe's survey, 91% of small business owners work with contracts at least monthly. 19% deal with them every day. Tip 1. Create templates for your common contracts. Don't reinvent the wheel every time. Have a professional review your templates once, then use them consistently. Tip 2. Maintain a contract calendar. Track expiration dates, renewal deadlines, performance milestones. Set reminders well in advance. Don't get surprised by automatic renewals. Tip 3. Build relationships with legal professionals before you need them urgently. Have a lawyer you can call for quick questions. The cost of preventive advice is nothing compared to litigation costs. Sometimes the best contract decision is to walk away. No deal is better than a bad deal. Knowing when to leave takes courage and wisdom. Walk away when the other party won't negotiate any terms. The risks dramatically outweigh the benefits. You can't get adequate protections. Something feels fundamentally wrong. Walk away when the other party is pressuring you to sign immediately, without time to review. They're making verbal promises they won't put in writing. Their explanations don't match what the contract actually says. Trust your instincts. If something feels off, it probably is. If the deal seems too good to be true, if the other party is evasive about questions, if you feel uncomfortable, walk away. There will be other opportunities. You've learned a lot today, but knowledge without confidence doesn't help much. Let me help you build the confidence to use what you've learned. Practice reading contracts. Find contracts you've already signed. Apartment leases, employment agreements, phone contracts. Read them carefully. Identify the elements we've discussed. Notice the clauses we've warned about. Ask questions without fear. Remember, the other party wants to make a deal. Asking for clarification doesn't kill deals. It shows you're serious, professional, careful. Most people respect that. Start with small stakes. Practice your contract skills on smaller agreements before tackling major ones. Build your confidence gradually. Each successful negotiation builds your skills for the next. Let me give you a practical checklist to use every time you encounter a contract. Save this. Use it. It will guide you through every agreement. Step 1. Read the entire document. Yes, all of it. Mark anything you don't understand. Step 2. Identify the 6 elements. Is there an offer, acceptance, awareness, consideration, capacity, legality? Step 3. Check for dangerous clauses. Automatic renewal, arbitration, indemnification, limitation of liability, non-compete? What jurisdiction? Step 4. Ask your key questions. What are my obligations? How do I get out? What if things go wrong? Let's reinforce the 6 elements one more time. These are the foundation of everything. Offer. One party proposes specific terms. Acceptance. The other party agrees to those exact terms. Awareness. Both parties understand they're entering a binding agreement. Consideration. Something of value is exchanged between both parties. Capacity. All parties are legally able to enter contracts. Legality. The contract's purpose is lawful. All 6 must be present. Missing even one can make the contract unenforceable. This is your framework, your foundation, your power. And let's review your key protections, the shields that defend you when things go wrong. Documentation protects you by providing evidence. Proper termination protects you from becoming the breaching party. Understanding your remedies ensures you know what you can pursue when someone wrongs you. Reading before signing protects you from agreeing to unfavorable terms. Negotiating protects your interests up front. Knowing when to walk away protects you from bad deals entirely. These aren't just concepts, they're tools. Use them every single time. Knowledge without action is useless. So here's what I want you to do today. Not tomorrow, not someday, today. Action 1. Find one contract you signed in the past year. Read it, all of it. Identify the elements. Notice what you missed before. Action 2. Create a folder, physical or digital, for all your important contracts. Organize them. Know where they are. Action 3. Set calendar reminders for any contracts with renewal dates or deadlines coming up in the next year. These 3 actions take less than an hour, but they put you ahead of 90% of people. Do them now. Your learning shouldn't stop here. Contract law evolves. Your situations will change. Keep educating yourself. Read contract terms when you encounter them. Every agreement is a learning opportunity. Notice patterns. Recognize standard clauses. Build your intuition. Consult professionals for major decisions. The cost of good legal advice is always less than the cost of bad contracts. Build relationships with professionals you trust. Stay updated on laws affecting your industry. Consumer protections change. Employment laws evolve. Technology creates new contract questions. Keep learning. You now know more about contracts than most people will ever learn. You understand the 6 essential elements. You recognize dangerous clauses. You know your remedies when things go wrong. Remember what we started with. 91% of people sign without reading. 12 million contract lawsuits are filed against small businesses every year. The median lawsuit costs $91,000. But now, you have the knowledge to protect yourself. Contracts are not obstacles. They are tools. Tools that protect both parties. Tools that create clarity. Tools that build trust. Tools that make business possible. When you understand contracts, you have power. Go out there, read carefully, negotiate confidently, protect yourself wisely, and never, ever sign something you don't understand. You've got this. Thank you for spending this hour with me. Now go use what you've learned.